This is The Law Show on CL 650. Now back to the show.
Rudy Kisher and Alex Stojcevic are immigration lawyers with Maynard Kisher Stojcevic in Vancouver. They are our guests on this episode of The Law Show here on CIL 650. I'm Sterling Fox, and before the break, we were talking about family class applications for citizenship in Canada. We started talking about those individuals, and Alex, you mentioned the two categories. One is admissibility, and the other is selection. And every person who applies for immigration to Canada must go through the process involved in both of those categories.
Correct, absolutely. Both of those are the two essential decisions in every immigration case. Now, when we talk about what we're talking about in this segment, dependent children, the question becomes, is this your child?
Okay.
And this seems like a silly one in a way. Well, it's my child. Of course it's my child. But this comes up in some interesting legal quandaries and things that our law right now is struggling with, where the law hasn't actually kept up to some extent with reproductive technology. And we're going to get to that in a minute.
Okay, well, before we get to the special children,
sure,
can we just talk about children who are biologically traceable?
Yeah,
go ahead.
Well, they've got to be dependent first. So it's not just any children, it's got to be dependent.
So that would be up to university age?
Well, you would think. That would be kind of the normal North American, Canadian normal, that your
18,
child...
19, something like that?
Or having finished university. So the old rules used to be when you turned 22, or if you were still in school, you were considered a dependent child.
Right.
They changed that recently, and they've backtracked it. They were having problems with people that had, turned 22. Were they still in school? There was issues about, how did you show they were still attending school? Was it school that they were going to just for the immigration process and they weren't attending? And immigration got tired of having to litigate this and argue about this, so they changed the rule. But instead of saying the rule, say, okay, you turn 22, you're no longer dependent. That sounds reasonable.
Right.
I think most people would say North America, that's kind of a normal
That's
mindset
quite
here.
Generous, yes, yeah.
Well, they've rolled it back to 19.
Okay.
So if you're 18, you're fine. The minute you turn 19, you're no longer dependent. So
even if dad's paying for your college education and you're enrolled at UBC and you're only in your second year,
and you're living at home in the basement,
no visible means of support beyond what the bank of mom and dad is giving you, you're still at age 9, as of your 19th birthday, you no longer qualify for Canadian citizenship?
For permanent residency, to be sponsored by a Canadian permanent resident or citizen.
So then how do you get around? How do you dodge that?
You've got a massive problem, because now you're at the point where you're no longer dependent, but you're not a skilled worker. You haven't finished university.
Absolutely, yeah.
You don't have any work experience to say that you've picked up some skills. And this is a new category of people that we're advising people, much to their shock. They're like, well, how is that person not part of my family? They're still in school. They're still living at home.
Right.
I'm paying for them, everything. And they're not able to live on their own, not in this society where, it's assumed that you need education beyond high school for the majority of jobs.
Right.
And it's a new problem that we're having to deal with. So we're having to look at applications of where you maybe have the person come here on a study permit, pay foreign student fees the whole time, which are astronomical.
Sure.
Or wait abroad until you're able to come.
So you're neither dependent nor independent either.
So
and
would you have to jump on a plane, Alex, after your 19th birthday and buzz off, do some paperwork back in the old country before you'd be allowed to continue living in Canada and go back to school next week?
Well, listen, Sterling, the key problem is that the parents of these people aren't even bothering to apply. Because look, if you're in your mid-40s and you're looking at immigrating in any of the categories that are open to you, are you seriously going to not immigrate with your 19-year-old? I mean, that's a decision that people will not make.
Right, okay.
More often than not.
Right.
They'll say, listen, I'll bring the 12-year-old and the 10-year-old, but you, 19-year-old, you'll have to stay home. That's not a decision that people these days anywhere in the world would make lightly, I would think. And that's been the hard and fast effect of this change.
So when did this change come into effect, the dropping of the age down to 19, Rudy? Is that a 2015 change as well?
2014.
2014.
Okay, so it's still very, very new.
Very new.
Yeah. And so I gather by the shared looks here that you're getting a lot of calls from a lot of parents.
You can imagine an executive working here for 3 or 4 years thinking he's going to be able to immigrate, and his son is, 18, finishing high school, comes into our office, and we're like, well, if we don't get this application in now, this person is no longer a dependent. We have to get this in now, or else your son's going to have to pay foreign student fees, stay here as a student, and then work for a couple of years before they actually qualify to immigrate on their own.
Right. Even though the rest of the family, that university students' younger brothers and sisters, will all they all qualify under both of Alex's categories, so they're admissible and they've been selected and they'll get citizenship. The older brother may not.
Yeah, so this is, the party, the Conservative Party that, considers family values important, has definitely reworked the definition of family to one that really doesn't fit the current Canadian picture, I would say.
Okay, so any children under 19, though, Alex, are pretty much, if you come in with mom and dad and go through the formal process of applying, all the paperwork is in order, then it's pretty easy?
Except in the following situation, and that is if as long as you declared this child at the time that you immigrated. Now, what am I talking about there? I'm talking about Regulation 117.9d. So let's say you immigrated with your second wife and your child from that marriage.
Okay.
If you declared the child from your first marriage that you had, and that child is under the age of 19, and that child was examined as part of your application, so that they made an admissibility decision about that child from the first relationship, if you declared that child at that time, you can sponsor that child later. If you did not declare that child, for whatever reason, it is practically impossible to bring that child to Canada later.
That's a horrible penalty for somebody who, admittedly they made a misrepresentation. They should have included. But you think about someone who's come here, would like to have their child there. They haven't committed a crime or anything.
Right.
They just haven't talked about a child. And in some cases, we've seen cases
where they
didn't
even
know
know they
about
had
the
a
child.
See, I was just going to say, Rudy, you've worked abroad. You've worked in Hong Kong. You know about what it's like to get good information across the pond, wherever that may be. And it's really tough to get information. And I know it's the computer age, but the Government of Canada websites are just awful. And so how do people, I imagine in a lot of cases, people quite innocently shoot themselves in the foot, so to speak, by not knowing enough about the rules.
Yeah, it's heartbreaking. They often get advice, not going to a lawyer, not coming and talking to somebody. They end up talking to their friends, and their friends, don't put your family member on there because it's going to take too long. It's going to slow things down. And you often see this, especially unfortunately with the community that works as living caregivers. They often, it's too expensive for them to go to a lawyer. They feel that they can't afford to even come in for a consultation, and they don't get that legal advice. And it really hurts them at the end.
And there's some heartbreaking situations. You have situations where the 19-year-old has had a child and hasn't told the parents, because to do so would cause all kinds of
great
concerns.
Family strife, right?
Or has told the parents, and the parents insist that they don't disclose because they don't want their application to be slowed down anymore by the act of their child.
Right.
Then you have unfortunately a situation that's not uncommon in Canada, which is where someone has not disclosed to their current spouse that they had a child before their relationship, or in some cases during their relationship. And situations like that mean that child literally ceases to be a member of the family class, and you cannot sponsor them even if they are under the age of 19.
Now, we have an appeal process.
I was just going to get to that. Okay.
That, so you can look at, well, I didn't know about the child. I had a relationship. It was short term. I never talked to the woman again. I found out later I have this child. I'd like to bring him to Canada. But when you immigrated, you didn't disclose that. We used to have a process where you could go to the Immigration Appeal Division, part of the Immigration Refugee Board, and tell your story.
That was my question. How do you unravel all of this to the benefit of the person who, in many cases, just didn't know?
Well, you used to have an opportunity to tell that story,
right?
To an independent person that would sit and listen. They'd hear the evidence. You'd give a chance to, you'd be cross-examined on that evidence. You'd be able to gather other sort of documentation and put it in before a reasonable tribunal. Unfortunately, they changed the law and said that person, you no longer even have a right to appeal that. So that appeal right is taken away, so you're left with what's left as a humanitarian and compassion application. And the chance of getting that appealed successfully, reviewed successfully, is pretty close to zero, would you say?
Well, there's been statistics done on these through a number of different avenues, and they've been collated by a number of different organizations in Canada. They're not high. Like, your chance of success in a case like this are somewhere between 11 and 17%, depending on the year.
That isn't very good.
And that's where there's nobody really There's no issue that this is the person's child, by the way. No one ever doubts that in these cases.
So it was an issue of disclosure.
It's the disclosure part and the integrity of the system from the government's perspective.
And Rudy, you've always maintained, and we've had a few conversations about this, whenever anyone, and you do nothing but advise people on immigration matters. And one of the things that you and your partners are quite insistent about is always tell the truth. Yeah. Even though it may be uncomfortable, even though some of the truth that comes out may be a brand new headline to other people in your life, nonetheless, when it comes to the government of Canada, tell the truth and take your chances from there, right?
Yeah, because we always have an argument. When the truth is told, there may be an argument that we can look at to overcome the situation that may seem awkward. There may be reasons for this. We can explain that. When a misrepresentation happens, it makes you inadmissible.
Right.
Yeah, and it could make you inadmissible now for 5 years, right?
And to make matters worse, I mean, these misrepresentations now in these types of situations, given that the government is changing the administrative process for revocation of citizenship, you could be putting your Canadian citizenship at risk if you come forward and try to sponsor a child like this that you didn't disclose at the time that you applied.
Really? So they consider that an egregious sin, that fibbing on a government document or failure to disclose completely information could ultimately cost someone their citizenship.
Yes.
Wow. And all of this is effective since when? Is this last year as well, since 2014?
Well, the changes to the Citizenship Act are only taking effect in June of this year, and they're coming up with a completely new revocation procedure, one that has gone from being tied to the federal court and a trial process in federal court, which limited this to maybe 20, 30 cases a year, to an administrative process that's going to be managed by the government directly.
So changes already in 2015 on January 1st, just a few days ago on April 1st, more on the way on June 1st. And you think it's confusing for you. Imagine how the lawyers trying to sort through all of this stuff must feel, and it's their job to help you. So we'll talk more about how that help can be found and how to get good advice with our guests, Rudy Kisher and Alex Stoychevich from Maynard Kisher Stoychevich Immigration and Citizenship Lawyers, online at vancouverlaw.ca. Check it out while we take this quick time out.
There's more of the show still ahead. This is The Law Show on CL 650.